All right. Hello, my name is Zach Shields, and I'm a member of the Dole Institute Student Advisory Board. Welcome to the Dole Institute of Politics, and thank you for attending tonight's presentation. The Dole Student Advisory Board is composed of KU students committed to the work of the Dole Institute. We attend regular meetings, assist in events like this one, and plan an SAB-sponsored program every semester. Members of the SAB receive great opportunities to network with our special guests. If you're a student and would like to join, please contact the Dole Institute. The Dole Institute would like to hear from you. If you enjoy tonight's program, please let us know by contacting us on Facebook, Twitter, or through a website email. Your attendance and feedback help shape future programming. Before we begin tonight, I'd like to remind you to please turn off your cell phones. After the interview, we will have some time for audience questions and answers. If you have a question, please raise your hand, and a student helper with a microphone will come to you. Please ask just one brief question. And now, please welcome the Associate Director of the Dole Institute, Dr. Barbara Ballard.
Thank you, Zach. Certainly, we want to welcome you. I'll say good evening and welcome to the Dole Institute of Politics. As you know, this is our annual Constitution Day recognition. On September the 17th, 1987, the Constitution was signed by 39 of the 55 founding fathers. In 2004, President George W. Bush signed a bill designating every September the 17th as Constitution Day. We have had several celebrations on our campus, and I think, as all of you know, any institution that receives any federal dollars has been asked to do Constitution Day programs. We're ahead of the game because we were doing it before we were even asked to do it, and we had several programs and celebrations on campus. We did one on Wesco Beach on September the 17th. We also have our naturalization ceremony here, where we recognized 100 brand new citizens to the United States, and that was right in this very hall. We did the reversal where they were facing the flag on September the 17th, and at Memorial Stadium, we also celebrated by doing the preamble to the Constitution, at which point that's what I'm going to ask you to please do with me as well. So in your program, you'll notice right on the corner, on your left corner, is the preamble to the Constitution. So I will start by making a little ceremony. Would the bell ringers do their job? Oh, you're doing it well. All right, at this point, I will start and ask you to join in on the preamble to the U.S. Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution for the United States of America. I think often, oh, go right ahead. I didn't bring my bell up here, so you have to ring for me too. And when I pass it out and I said ding-a-ling, somebody says, are you calling me a ding-a-ling? No, I did not do that. But I do want to thank you very much. As many of you know, we are celebrating our 10th anniversary of the Dole Institute of Politics being on the University of Kansas campus in this building. We've been here longer in terms of forming it, but in this building. And we have had lots of programs, as you all know, and the Constitution is one of those. So with our 10th anniversary celebration and our Constitution Day, I'm just really pleased to say that we have had 10 years of Constitution Day programs. The last 4 have been dealing with cases that were of national prominence with the U.S. Supreme Court. The first being Snyder versus Phelps, where we discussed the First Amendment. The second was Affordable Care Act, where we talked about health care. Last year's was affirmative action, and this year we're dealing with campaign finance. As many of you are aware, the U.S. Supreme Court held arguments this morning. Normally, it's about a week or 10 days out, but they held the hearings this morning, so you can expect, and Steve will tell you if they're going to continue hearings or was it just this morning, and normally it'll be months before you find out what their opinion might be. I would also say to you to turn on the back of your program and notice our programs, our Dole Fellows Reunion. That's part of our 10th anniversary celebration, and you can see the dates and time, October 10th and 11th, and you'll have the opportunity because many of our fellows will be coming back for that. David Boaz from the Cato Institute has a program on October the 17th, and we're about to celebrate on our campus KU Civic Engagement and Leadership Week. And something new to what we're doing this year is that we will be participating in the National Make a Difference Day on October the 26th, which will be part of our Leadership Week. We also have the 10th anniversary series on disabilities, the evolution of equality with David Morrissey, and that's a program I'm sure you would like to attend. We also have the Dole Leadership Prize, which we just announced last week, of which we will be giving our Dole Leadership Prize to President Nelson Mandela, and his great-grandson will be here to accept on behalf of his great-grandfather. And our last program we have listed here is a tribute to the veterans, our USO style here. For those of you who have been, this part of the floor becomes the dance floor. We have Moonlight Serenade Orchestra, and we invite all of our veterans, friends, and their families to attend. Now I'll just proceed with our program for the evening, and we're very honored to have our guest. I would also like to tell you when I talked about those 4 programs before the U.S. Supreme Court, we could not have done that because this program is being presented, as always, with the School of Law. And also I'd like to thank Steve McAllister because he has helped us mastermind a lot of our programs, did the contact, did most of the legwork in terms of inviting all of our guests to attend. And probably we could have found some way to do it, but Steve McAllister had the expertise. He wanted to do it, and we're very grateful to the School of Law, and our Dean Maza is here with us this evening as well. For our 2 guests, I would do their introductions, but I think you know that today the U.S. Supreme Court will hear oral arguments, and they did hear in another important campaign finance case, McCutcheon versus FEC, which raises questions about the current limits under federal law on the amounts that individuals can contribute to campaigns and political entities. In light of the court's landmark decision in Citizens United versus FEC 2010, allowing corporations to spend general corporate funds in elections and campaigns, there is much debate about the current state of campaign finance laws and the influence of money on elections. Many people will say, is it big money versus small money? Is it big money versus lots of little tiny small monies? And are we buying elections? Are the elections really what we would want in our country? I would also say this program will feature 2 prominent attorneys, which you see before us on opposite sides of the constitutional issues. As always, we keep civility in all of our programs, and we generally invite people that know how to do that as well. You will have your opportunity to ask your questions, as all of our programs have, and I hope you will enjoy this discussion on constitutional law of campaign finance. I will start with Bobby Burchfield, one of our panelists this evening. He is a partner in the law firm of McDermott, Will, and Emery, based in firm's Washington, D.C., and he serves on the firm's management committee. Previously, he served on the firm's executive committee as head of complex litigation, and for 9 years as co-head of the firm's Washington, D.C. office. He argued the 2003 McConnell versus FEC in the United States Supreme Court at the George Washington University Law School. And at George Washington University, I should say, he was editor-in-chief of the Law Review. And from 1979 to 1981, he clerked for George Ruggiero de Aldershot of the U.S. Court of Appeals for the Third Circuit. In 2006, he received Wake Forest's Distinguished Alumni Award. He currently serves on the Dean's Board of Advisors at the George Washington Law School, and he's a member of the Economic Club of Washington and formerly served on the board of the National Republican Lawyers Association. He graduated from Wake Forest University with a BA in 1976 and from George Washington University Law School in 1979. Randy Moss is the chair of the firm's Regulatory and Government Affairs Department and a member of Litigation Controversy Department. He is also a member of the firm's Government and Regulatory Litigation, Appellate and Supreme Court Litigation, Defense, National Security, and Government Contracts and Strategic Response Practice Groups. That is a mouthful. Mr. Moss joined the firm in 1989, and he's a member of the firm's Management Committee. He originally joined the firm after serving as a law clerk to the U.S. Supreme Court Justice John Paul Stevens. From 1996 to 2001, he served as a senior official in U.S. Department of Justice, culminating in his appointment by the President and confirmation by the Senate as the Assistant Attorney General for the Office of Legal Counsel. Mr. Moss has focused on complex civil litigation, appellate practice, administrative and constitutional law, and national security law. He graduated with a BA from Hamilton College in 1983 and received his JD from the law school, Yale Law School in 1986. Our moderator this evening is just as distinguished, and as I told you before, really plays a major role in making sure that these programs are brought to you. Steve McAllister will serve as the moderator this evening, and he's a native Kansan who grew up in Lucas, Kansas. He graduated from the University of Kansas in 1985 and from the University of Kansas School of Law in 1988. Following his graduation from law school, he clerked for Judge Posner of the United States Court of Appeals for the 7th Circuit in Chicago, Illinois, and then for Justices Byron White and Clarence Thomas of the Supreme Court of the United States. In 1993, Steve returned to University of Kansas School of Law as a visiting law professor. He served as dean of the KU Law School from 2000 until 2005. He won the W.T. Kemper Award for Excellence in Teaching in 1999, and as a scholar, he has written on a variety of constitutional topics, including affirmative action, capital punishment, federalism, and sex offender laws. He's also appeared before the Supreme Court of the United States several times, and he served as the first state solicitor for Kansas, assisting the Kansas Attorney General's office in state cases raising important constitutional issues. Before you, you see three very distinguished lawyers with expertise in all of their areas, and they will be addressing campaign finance, and as you see the rest, has Citizens United changed the rules? I will turn the program over now to our moderator, Steve McAllister, and I would like to ask you, please, to give a warm Jayhawk welcome to our guest this evening.
Well, thank you very much. It really is a pleasure to have these two with us. They've come a long ways together. I think they're heading back early in the morning, and Bobby Burchfield was actually in the Supreme Court this morning arguing in the very case we'll talk about. So I don't know that that's ever happened, that someone argued in the Supreme Court and came to Lawrence, Kansas to talk about it that very same night, but he has. And Randy Moss, we believe that we've actually played basketball together when we overlapped briefly as law clerks at the court. So it's a personal pleasure as well as a professional pleasure for me to have both these gentlemen with us. And we want to start by setting the framework a little bit. So I'm going to ask them kind of a combo question. They've seen a list of things we'll talk about. But to start setting this up, and then we'll get into the case that was argued today, as well as Citizens United that many people are aware of and have strong feelings about one way or another. So by way of background, could the two of you just maybe take a turn at kind of explaining a little history, if you will, of campaign finance reform and any Supreme Court decisions that kind of set ground rules that you think would be helpful for the audience to know about?
Well, sticking to a little history in this area is difficult, but I'll kick it off with just a little bit. And a lot of the principles, and the reason that it's hard to do just a little bit here is it goes back to the early days of the 1900s. Can we turn the mic up a little bit?
No, I can't hear you.
Okay. Well, I'll
There you go.
Okay, there you go. All right, good. So the story, from my perspective, starts in 1907. Teddy Roosevelt was a great reformer, and a lot of the debate that exists today, folks would be surprised, existed in 1907 as well. And the question of whether large campaign contributions from corporations whether that had an effect on our democracy, whether it affected public confidence in our democratic institutions. And all the way back in 1907, Congress passed its first major law in this area. They jump ahead to make this as quick as quick, but you jump ahead all the way to the 1970s. Congress in the 1970s adopted the Federal Election Campaign Act. It's referred to as FECA. And after originally enacting it, the Watergate era came, and Congress then fairly promptly afterwards amended the law, I believe in 1976. That actually really starts the framework of what we're talking about here, because that's when Congress adopts the rules that look a lot like what we're talking about today, and adopts three things that are relevant. One is adopts contribution limits. Two, adopts limits on expenditures, how much money you can actually spend on a campaign. And three, adopts aggregate limits on a total amount that you can contribute to political campaigns. Congress considers all of that, the Supreme Court considers all of that in Buckley versus Vallejo, one of the landmark cases, and probably the landmark case in this area. And the court in Buckley sort of creates a structure that becomes the structure of the campaign finance laws for the next 40 years or so. And what the court does is it says that with respect to the expenditure limits, the limits that say how much you can actually spend on political advocacy, that gets at the core of speech. It could not be more core to our political system and to the First Amendment to regulate how much money people actually spend and how much speech they actually engage in. And because of that, the court applies what they refer to as strict scrutiny. It's the highest level of scrutiny the Supreme Court applies in any type of case. It says those rules are only going to be upheld if they serve a compelling governmental purpose. It's a very, very high standard to meet, and the court concludes it's not met with respect to the expenditure limits. But with respect to contribution limits, the court says that actually doesn't involve the same type of core political speech, because you've got to think about it from the perspective of either the contributor or the person who's receiving the contribution. From the perspective of the contributor, the size of the contribution is not particularly important. There's not a great deal of speech that goes into whether you contribute $100 or $1,000. What is important is the symbolism, your symbolic speech. I like this person, I support this person, and therefore I'm going to give this person a political contribution. And then it also affects, obviously, the speech of the recipient, but in a much more indirect way, because the recipient needs money to engage in speech, but it's not the person who's actually making the contribution who's engaging in the speech, except the symbolic speech. It's the person who then receives the money and then spends it. And the court says because of that, because it's much more indirect, it imposes less on the First Amendment values, the court is going to apply a lower level of scrutiny, and it's going to uphold the law if it's what the court says is closely drawn to serve an important governmental purpose. And the court says that contribution limits are, because they prevent either actual corruption or the appearance of corruption from keeping people from making massive political contributions to candidates or their parties and then expecting some quid pro quo. Not necessarily where there's an actual agreement that would be a crime and the person could be prosecuted for the crime, but where there's a wink and a nod or an understanding that when that individual or company shows up, that they're going to be treated better. And the court says that is a sufficient basis to uphold the contribution limits. A lot then happens in between, and I don't want the story to go on too long, and we can maybe come back to some of the later to what happens in between. But what comes now with the case that Bobby argued this morning in the Supreme Court, the question comes up of whether the aggregate contribution limits that exist in the law today are constitutional. And there are two sets of aggregate limits. There's one aggregate limit that applies to how much you can actually contribute to particular federal candidates and to their authorized committees, and that amount is $48,600 an election cycle. And then there's a separate amount that applies to how much you can contribute to the political parties and the non-party committees, and that's another $74,600. And so the question that we're going to be talking about today is whether those contribution limits, the aggregate limits, not the individual limits, as people may know, there's a separate limit of $2,600, for example, that you can contribute to a particular candidate. That's not what's at issue. It's the total limits where you aggregate everything together. That's what's at issue here.
I think Randy's done a very good job of outlining the overall history and development of the campaign finance laws. Just to briefly go through that and add a couple of things. The modern era of campaign finance regulation began, as Randy said, with the Federal Election Campaign Act in 1971. Shortly thereafter, we had the Watergate scandal, and Congress amended the statute in 1974 and added a great many restrictions, which the court reviewed in Buckley versus Vallejo. After that decision, Congress went back and incorporated the findings, the rulings from the Supreme Court in Buckley, passed the statute again in 1976. That law was essentially in effect, changed a few times, but essentially in effect up until 2002, when Congress passed the McCain-Feingold legislation. That legislation was reviewed by the Supreme Court in the McConnell decision in 2003. The Supreme Court largely upheld it, and from there we have the Citizens United decision, which overruled part of the McConnell decision, and leading up to today, where we have the argument on the aggregate limit. The aggregate limits, by the way, as Randy says, there are two types of limits. One says I can give $2,600 to any federal candidate, $2,600 per election, and that Congress has determined $2,600 is not a corrupting amount. I think we would all agree any congressman that could be bought for $2,600 is not someone you want representing you. The aggregate limit, however, says if you give $2,600 to whatever it is, 16 or 17 candidates, it's a felony for you to give $2,600 to that 18th candidate. So it says you can give, it is legal for you to make that contribution up to a point, but then we limit your checkbook and you can't give to any more candidates. So the issue, as simply stated, some people have understood it when I put it this way, can Sean McCutcheon, the plaintiff in our case today, can Sean McCutcheon corrupt candidate Smith by giving money to candidate Jones? And I think the answer to that is no. The aggregate limit is there to just limit the amount people can spend on elections rather than to prevent corruption of individual candidates. But that's obviously a complicated issue which the Supreme Court dealt with for an hour this morning.
So we'll talk about McCutcheon in some detail, but I want to take you both back just for a moment. So talk a minute about 2010 and just make sure everybody understands what Citizens United actually did and what was at issue and how that changed things, perhaps.
I'll let you start this one.
Sure. Many of you probably have read news reports over the last few months that a couple of one television network, one cable network, were going to air miniseries on Hillary Clinton, and that was very controversial. In fact, the chairman of the Republican National Committee told NBC that if they ran it, he was not going to let them sponsor any of the debates in the 2016 election cycle. But no one doubted that NBC had the right to air this mini-series on Hillary Clinton, because NBC is, after all, a reputable media entity. Well, the Citizens United case involved Hillary the movie, which was a long documentary clearly slanted against Hillary Clinton that the group Citizens United wanted to make available to air on a cable network. And the issue in Citizens United was, can the government prohibit that? And the Supreme Court ruled that NBC, and this was long before NBC had announced it was going to do the Hillary documentary, but the Supreme Court ruled the media has no greater right to free speech than anyone else who is engaged in political debate. So the Supreme Court ruled that it was illegal, it was unconstitutional under the First Amendment free speech clause to limit the ability of Citizens United to air its movie. Now, I don't know, you may see the movie depending on what happens in the 2016 presidential campaign. I understand it's not a very good movie, but in any event, the principle was, does Citizens United have a right to air that. And the Supreme Court, in a long and careful decision, 5-4, ruled that prohibitions on corporate speech violated the First Amendment. And part of the reasoning was, if Congress can limit the right of Citizens United to air this ad, the First Amendment must mean that it could limit the right of a newspaper to publish endorsements of candidates, or of a network to air endorsements of candidates, and accordingly, we just don't see where you draw the line there. So that's my interpretation of Citizens United.
My interpretation of Citizens United is a little different. It goes back, actually, further back into history, and at least back to 1947, if not back to 1907. And at least since 1947, it has been unlawful for corporations, or it was unlawful for corporations in this country to spend their general treasury funds for purposes of political campaigns. They could set up a political action committee. The corporation could actually pay to administer the political action committee. The corporate employees, officers could contribute money that went into that political action committee, and they could spend that money however they wanted, but they couldn't use the money out of the general treasury for purposes of political advocacy. In the 1990s, a phenomenon developed called the so-called issue ad, where political parties and others started running so-called issue advertisements. And what they did was they avoided using what we refer to as the magic words of vote for or vote against. But anyone who looked at the ads would know that they were actually political campaign ads. They were ads like one of the famous ones mentioned by the Supreme Court in the McConnell case. There was a guy named Bill Yellowtail who was running for office in Montana. And the ad was something along the following lines. Bill Yellowtail says that he's for family values. Well, guess what? He beat his wife. And when he was asked about it, he said he just slapped her. Call Bill Yellowtail up and tell him to be in favor of family values. And there was ad after ad after ad that were run that were undoubtedly political campaign ads. And I could regale you with a list of how some of these wonderful ads, but they were clearly political ads. They were dressed up as though they weren't. And what Congress did in the McCain-Feingold law is they said, this is a charade. These are clearly political advertisements. We need to come up with some bright line rule to distinguish political advertisements from non-political advertisements, so that if a corporation is going to run these ads, they got to use money that comes out of their general treasury. They cannot use money out of the general treasury. They have to use the political action committee money. And so what Congress said was, if it's 60 days before a general election, for example, and you're running an advertisement that reaches a certain number of homes within the district where the person is running, and you mention the person's name, it's going to be treated as an ad. And the Supreme Court upheld that in the McConnell case. And what Citizens United did was overruled that. And Citizens United said that the burden of having to actually fund these things through a political action committee was too much of a burden for a corporation. And that as a result of it, corporations should be allowed to use their general treasury funds for running, whether it's political advertisements or long documentaries. That I think the issue in the case was whether it really was actually a political advertisement or whether it was actually a legitimate documentary. And that, by the way, was the issue that was being litigated in the case when the Supreme Court said, you know what, we actually don't want to decide or don't need to decide that issue here because we're going to throw the whole law out, and we actually don't need to decide whether the Hillary the movie was in fact the equivalent of a political ad or whether it really was a documentary.
Well, I think the court was pretty clear that if considered under the standards of the McCain-Feingold statute, it would be banned as a political ad, as corporate money spent to oppose a candidate. And it was having reached that conclusion, the court decided the First Amendment issue is now front and center. We've got to decide whether Congress can, consistent with the free speech clause, ban the distribution and airing of this corporate-funded movie.
Yeah, but I do think that it's important in sort of setting these issues up, and this may be a little bit of a side issue for today's purposes, but it was not a ban. There was not a ban on the speech. What the prohibition was on using money that came out of the general corporate treasury for purposes of that type of speech versus using money that came out of a political action committee.
Well, I think we disagree on that. Citizens United did not have a PAC, so if it had not paid for it, with the contributions that it raised, some of which were from corporations, not all, if it hadn't paid for it with corporate money, the ad would not have aired, so it would have effectively been banned. I take Randy's point that corporations can set up political action committees. The regulations governing political action committees are dozens of pages long in the Code of Federal Regulations, and the court said that's no substitute for being able to air direct speech. So,
All right. Well, so
is this enough disagreement for you?
we're getting there. I'm going to ramp it up a bit. So, so before we turn to McCutcheon again, since we've talked about Citizens United, simple question: right or wrong, and why, in your view, each of you? Does the court reach the right decision in Citizens United? Did it reach the wrong decision? And why would you say whatever you say?
Yeah, I suspect that you can guess what we'll say in light of what we've said already on this, but I thought that, I wrote a brief in the case. I thought that the decision was wrong. The court overruled a lot of precedent to reach that decision. It rejected a history going back to 1947 in doing so, and while I agree with Bobby that there is some burden involved in establishing a political action committee, it's not a great burden. And it's sort of interesting. You can find Supreme Court cases that say it's no burden at all or very little burden. You can find Supreme Court cases that say it's an enormous burden. I think as a practical matter, it is not difficult to set up a political action committee, and it strikes me as a reasonable means of ensuring that the sort of vast amounts of money that corporations are able to amass from their shareholders, who may agree or may disagree with the political message that they're sending, and the benefits that corporations have of the corporate structure, that it's not a lot to ask of a corporation that is subject to all sorts of regulations, and they, anything from labor regulations forward, they comply with these every day, to say you need to actually do this through a political action committee.
I differ. I'll tell you one vignette from the Citizens United argument, which is of some renown in my world, and Randy in my world, and that is at Citizens United was briefed and argued to the U.S. Supreme Court twice. The first time, the court was, as Randy says, trying to determine if it was actually covered by these restrictions in the McCain-Feingold law. And the court ultimately determined, I think, that it was, and they asked for rebriefing of the argument, and they wanted the rebriefing to focus on the question of whether the First Amendment would allow restricting speech by corporations. At the first argument of the case, the Assistant Solicitor General argued the case for the government, and the Assistant Solicitor General was asked, well, if we allow restriction on this speech by a corporation, does that mean that we could allow Congress to pass a law that would prevent a corporation from publishing a book that was favorable to or endorsed a candidate? And the Assistant Solicitor General, after several back and forths on this, ultimately said, yes, I think that is what it means. So the case was rebriefed and re-argued, and this time Solicitor General Kagan, who is now in the Supreme Court, showed up to represent the government, because this case had suddenly increased geometrically in importance. And so the administration sent in Solicitor General Kagan, and she was asked the same question, and her answer was pretty much the same. And that was very telling, because after you work through all the logic of it, it is very difficult to come to the conclusion that if Congress can restrict a corporation from spending money on political advertisement independently in an election, that you can't restrict a corporation from doing anything. Because the First Amendment, and this is pretty well settled, the First Amendment's primary purpose, when it was adopted by the framers, was to protect political debate in the context of election campaigns. That's what made this country different from the other countries at that point in time. Now, why do I agree with this decision? I'll give you a couple of reasons. The first is, and these are what the Supreme Court says in its decision, it's a long decision, but if you're really interested in this area, it's easy to find, and I would recommend a read of both the majority opinion and Justice Roberts' concurrence, which is very well done, and also the dissenting opinion, so you get a full range of the views. But what Justice Kennedy said in the majority opinion is, first, we have allowed corporations to engage in political speech unrestricted in other cases. Great case out of Massachusetts and called Bellotti versus Baird, which involves a corporation speaking out about a referendum on the ballot. The Supreme Court had no difficulty concluding the corporation had the right to do that. The second thing that they said was this statute restricts not just major corporations, but it restricts all corporations. It restricts me if I have a small family business that I've incorporated. It restricts me from engaging in speech. That's not the sort of thing that is encompassed by this amassing of wealth concern. The Supreme Court noted that it was increasingly difficult to determine. It was difficult to separate out some corporations that get a little bit of their money from some entities that get a little bit of money from corporations, but most of their money from private donors. So the Supreme Court concluded that that the Citizens United decision was not such a radical deviation from its prior precedent. In fact, it concluded the precedent had been inconsistent, and it reached the result that I think is the right result if you think through all the logical consequences of it.
Miranda, do you want rebuttal?
Well, just very short, actually. There was a lot that I'm not going to address at all, but two things. One is I don't. This was, by the way, this was interesting. This was actually now Justice Kagan's first argument in front of the Supreme Court, and it was a tough case. I mean, you have to stand up in front of the court, having had her assistant have the experience that Bobby just described. My recollection, though, is that she didn't actually give the same answer when the question was posed to her, and that what she said was, this is a law that has been on the books since at least 1947, and not once can anyone point to a single suggestion by anybody, any federal regulator, anyone, that anyone would ever go after a publisher of a book with respect to this law. And then the other thing that I just sort of wanted to tee up is I remember sitting at the argument, and Justice Scalia asked a question of then Solicitor General Kagan along the lines of what Bobby just said about, well, this law applies to the mom and pop shop too. I mean, it's not just these huge corporations. It applies to a family, an individual that has incorporated. And the answer to that is, you don't need a political action committee if you're an individual. You just do it as an individual. You don't need to use your corporation for purposes of running your advertisement. If you're an individual, just do it. You're allowed to. This law only applies to corporations, and it's kind of hard to fathom why you would have a situation in which you had someone who ran the local barbershop and it was incorporated with their local barbershop, and they decided they wanted to run a radio advertisement, why they would have to do it through their barbershop for a political campaign rather than just doing it themselves in their own capacity.
But in one instance, if the guy owns the barbershop, if he's the sole shareholder and he runs the ad in the name of the barbershop, it's a felony. But if he runs the ad in his own name by taking money out of his barbershop, it's perfectly fine. That's not sensible. And I think in the transcript for Justice Kagan, I think ultimately they did wear her down a couple of questions later, and she gave that answer. They can be very unrelenting in questions, as I can testify from my experience this morning.
Well, and so let's turn to that, the case from this morning. So you've talked about it a little bit, but how about if each of you would just sort of characterize what you see as the real issues in the case, and then, Bobby, you should be really rehearsed at this. What are your best arguments in favor of the way you want it to come out?
Want me to go first? Or
Since the court actually didn't give you a chance to do it today, since they interrupted Bobby after his first sentence and sort of took him off in a different direction. So I think that this may be his opportunity to present the argument that, that the court never let him get around to.
And for those of you who have never had the opportunity to see a Supreme Court argument, by all means, if you're in Washington and the court's in session, I would recommend you do it. It really is it's great. Well, I don't know if it's great entertainment or great theater or what it's great, but it's fun to watch it. Sometimes it's fun even to be up there. But as Randy says, it's the case that you barely open your mouth before you get questioned by the justices, and from then on it's just a series of very quick questions, and oftentimes you don't even get a chance to finish your answer before the next question comes. Justice Jackson, who was a famous Supreme Court justice, and prior to that Solicitor General, used to say that I always have 3 Supreme Court arguments. The first one is the one that I intended to give, the second one is the one that I actually gave, and the third is the one that I wish I gave. And so I have all 3 of those. Which one do you want to hear?
I can say notwithstanding that Bobby actually gave a very good oral argument today in the Supreme Court.
The other thing that I would say about the Supreme Court, about arguing the Supreme Court, is oftentimes the attorneys find themselves as mere props for the justices talking to each other. So they will ask, well, Mr. Moss, wouldn't you agree that, well, X, Y, Z? And then another justice will pipe in and say, well, Mr. Moss, isn't it also true that, A, B, C? And then the first justice will come back with another question. And you'll end up standing there basically going back and forth without ever having a chance to say a word.
And, and you're really in trouble when one of the justices says, I would have thought your answer should have been.
The answer to that is always, yes. Absolutely, Your Honor. So in any event, the McCutcheon case, the issue in that case is, as we indicated earlier, is whether the aggregate contribution limits are consistent with the free speech clause of the First Amendment. And by that we mean, do they serve a government interest of preventing corruption or the appearance of corruption? Now, under the court's precedents, corruption in this context is defined as quid pro quo corruption, dollars to a candidate that are either for a political favor or that give the appearance of a political favor. Recall that the aggregate limit doesn't change the amount of money I can give to an individual candidate. I can still only give $2,600 to an individual candidate. So I can give $2,600, $2,600, $2,600, so forth, up to the 15th or 16th donation of $2,600, and then suddenly stop. So if I were to give $2,600 to that 18th candidate, is that more likely to corrupt that 18th candidate than giving the $2,600, the legal limit, to the first candidate I give it to? So our argument against the aggregate limit is that it does not serve any anti-corruption purpose, that the real reason for the limit, and we cited legislative history of the congressional debates for this, both from the original aggregate limit back in 1974 and from the current aggregate limit that was passed in 2002, is that what Congress was really trying to do was limit the total amount of money people could spend on politics. Now, why would that? And that is not an acceptable reason under the First Amendment, because the First Amendment primarily is intended to protect free and open debate in this country. And the fact that someone can speak a lot, you could buy a bigger megaphone, doesn't mean that you should be restricted. So the court has made clear since the Buckley case that leveling the playing field so that we bring the people who want to speak more down to the level of people who want to speak less or can only speak less, that's not a legitimate concern under the First Amendment. And so the argument against the aggregate limits is that they don't serve a government interest that is sustainable under the First Amendment, and therefore they must be stricken down.
And my take on it is that the world of politics and the way Washington works is not a world in which there are these hermetically sealed relationships that a contributor has with an individual candidate or individual office holder. The way Washington works is it works through political parties, through party leadership. The way money is raised in Washington around the country is oftentimes through what are referred to as joint fundraising committees, where the political party will host an event with members, and the money all comes in a single event, in a single check, and then gets distributed amongst those who are participating in the joint fundraising activity. And so I pose sort of a somewhat different hypothetical or question. It's not, what is the incremental risk to the integrity of the system when someone writes that 18th or 19th check or 20th check for $2,600 or $5,200 over a primary in a general election. It's not, what's the incremental harm there? The question is, what happens what is the harm when someone goes around and they say, I've got some really important issues in Washington. And there was a huge record of this occurring before the McCain-Feingold bill was enacted, and a huge record of actual and apparent corruption that occurred. But what happens is, I want to build something or other, and I need federal permits to do it. I've got some huge issue with respect to the federal government. You know what I'm going to do? I am going to give $5,200 to every single candidate for the House of Representatives from a particular party. It can be Democrat or Republican, doesn't matter, for that election cycle. I'm going to give the maximum amount that I can give to the national political parties at the same time. And you know what I'm going to do? At the end of the day, and I could probably do this all probably at one event, but it doesn't really matter whether I do it at one event. It's going to be known. There's not going to be any doubt that the leadership in Washington knows I have given millions of dollars to this political party. By and large, by the way, most of the candidates are actually in safe elections, and the money doesn't matter to them. They can transfer that money then to the people who are actually not in safe elections. It all comes together in a way that protects the political party and the interests of the political party, and the political party is made up of the members. When you talk about the congressional campaign committees, those committees are run by the actual candidates and office holders in Congress. So it's not divided. The world is not divided up that way. It is part of a political landscape in which individuals will know, if the aggregate limits go away, that they can give millions and millions of dollars to help a particular political party, and that they will receive, or will actually receive, or there will be the appearance that they have received favors in light of doing this. In the record, in the McCain-Feingold case, where there was a system that was similar to this, the soft money system, which has now been abolished, but it was a similar thing where there were massive amounts of monies that would come into the political parties. There was a record where we actually had declarations under oath from actual members of Congress saying things like, I was filibustering a bill, and someone else in my political party came up to me and told me I had to stop because there was a large contributor that wanted something on the bill, and they had given us a lot of money, so I had to stop it. And there were example after example of things like that. And so if the aggregate limits disappear, we will return to a system like that where massive contributions can be provided. They might be provided on an individual basis, but they can be provided through a single check as well, through one of these joint fundraising opportunities, fundraising committees, and you'll end up with the same system of just massive amounts of money, and the public once again sort of scratching their heads about the integrity of the political system.
Politics is the most heavily regulated industry in America, if not the world. Every dollar you raise for a federal election has to be reported, and every dollar you spend has to be reported. You are subject to limits on how much you can raise from whom and when you have to report it, and you have to file reports on a regular basis with the Federal Election Commission. There's no other industry in America, and I've represented a lot of different industries, that is regulated nearly as much as the political industry. The McCain-Feingold bill dealt with a completely different issue than the aggregate limits here. The McCain-Feingold bill dealt with a situation in which political parties, not candidates, but political parties could receive unlimited contributions from individuals or from corporations. And here, the aggregate limit, eliminating the aggregate limit would not do anything to eliminate the source restrictions, that is the corporate prohibition on corporations giving money directly to candidates or giving money directly to political parties, and it wouldn't eliminate the base limits. So any individual, even in Randy's hypothetical, any individual could still only give $2,600 per election to a particular candidate. $5,200 for the primary and the general together. He's right about that. But those are the current limits. An individual could only give $34,600 to a political party committee. That will not change if the aggregate limit is eliminated, and they could not give more than $10,000 to a state political party. That would not change if the aggregate limit is eliminated. We heard a lot today, and this is Randy's right. This is the principal defense by the Solicitor General this morning of the aggregate limit, that every candidate, all 435 Republican candidates that are running at one time, and all 33 Republican Senate candidates, plus every state party, plus all three of the Republican national parties, the RNC, the National Republican Senatorial Committee, and the National Republican Congressional Committee, are all going to have this giant fundraiser, and they're going to raise $3.5 million. For any of you who have been involved in politics, that is a real speculative hypothetical, that you would ever get that many political entities on the same page at the same time. And in fact, the court was highly skeptical of that. Several of the justices were highly skeptical of that. It's also true that the Federal Election Commission, which has a book of regulations that thick, in 11 CFR, if you want to look at it, has 3.5 pages just on joint fundraising committees. And those regulations make clear that a joint fundraising committee must enforce the base limits, the $2,600 limit and the $32,000 limit on political parties. And it must enforce the anti-earmarking provisions, which means if you give money to the joint fundraising committee, you cannot direct an excess contribution through one candidate or one committee to another candidate or committee to exceed your base limit. And the regulations also say that the joint fundraising committee must inform every contributor of those restrictions. So without the ability of an individual to tell, wink and nod, that his contribution is going to go from one candidate through one candidate to another, or through a joint fundraising committee to a candidate to whom he's already maxed out, the only thing a contributor can do is hope. Because the joint fundraising committee has to follow the stated formula in its written document as to how to allocate those contributions. And it can't violate that, because that would be violation of the law. So the joint fundraising example, it gets to a large dollar amount through several, we think, unrealistic assumptions, and it makes some assumptions about the distribution of the money that we believe are not consistent with the regulations.
And just to respond to those 2 points for a minute. With respect to the distribution, I mean, that really is not fundamentally the point. I mean, I think that there are ways in politics that people do engage in the wink and the nod, and there is the distribution. There's a history of people not actually violating the earmarking rule, but making it pretty clear where their money wants to go. But put that aside. I mean, that's not necessary for the point I'm making, because the point I'm making is that the individual candidates and office holders care about their political party. They are members of their party. If you are in the majority in Congress, there are huge advantages that flow to you if your party is in the majority. I mean, you actually move offices at times.
You can shut down the government.
You can shut down the government. Well, there are huge advantages to being in the majority, and it doesn't matter whether the money flows to you personally or not. It's your party that you're concerned about. And if somebody is writing checks, massive amounts of checks to your party, people in Washington, in the Capitol, know that. They know who the really big contributors are. And the concern is that those really big contributors, regardless of where the money flows, get benefits. And the Supreme Court said that in the McConnell decision. It doesn't matter where the money flows. It's the act of soliciting the money on behalf of the political parties that gives rise to the actual or apparent corruption. And then with respect to Bobby's other point about the fact that these hypotheticals are far-fetched, I certainly agree with him that there were some justices who expressed skepticism. And that was it was one of the moments, though, where, as a spectator, you always sort of want to stand up and say, I've got an answer to that one. I'd like to stand up and answer that question. And it seems to me that there are at least two answers to that question. One is that campaign finance law is a little bit like, I should look to the dean here, like tax law in some respects, in that people know how to work the system. And there are enormous benefits. You win or lose elections based on who is more sophisticated in working within the legal rules as they exist at a particular time, but gaining the financial advantage. And if you are somebody who is sitting down figuring out how to manage the efforts of your political party going forward, and you're not thinking about these questions that we're thinking about, and not thinking about you could double, triple, quadruple the amount of money that you are bringing in by going out and soliciting someone and saying, you know what, you can contribute to every state political party in the country, all 50 of them. And you know what, you can contribute $20,000 for the election cycle, 10 for each election. You can do that. You can contribute $1 million right now, and we would really like you to do that, and we urge you to do it. If you're not doing that, it's a question, what you're doing sort of in that political role. So I think it's actually very realistic that this sort of thing would occur. And the other point I would make is it doesn't have to occur to the point of 435 different checks to different members. It's enough that if you just look, for example, at the 3 national political committees. So there's, for the Democrats and the Republicans, there's a Senate committee, a House committee, and a national committee. If you just look at the 3 for each of them, without the contribution limits, just giving the amount of money that you're allowed to give to them, you can give $194,400 just there as to those 3. That's without giving to the presidential candidate, whoever it might be. It's without giving to any of the state committees. So the numbers get up easily and quickly into the hundreds of thousands of dollars. And that is at a level in which there is a real concern that it gives rise to actual and apparent corruption. And Congress made a legitimate judgment that it had to, there's always at some level it's somewhat arbitrary where you draw the line, but they drew the line in a place that they thought was a fair and reasonable place to draw the line. And just one last thought on this before I pass the mic back, and that is, going back to where we started the discussion, you have to remember that the standard for evaluating, and the standard the Supreme Court has historically applied for evaluating a contribution limit, is different than the standard that's applied in the Citizens United case and cases like that where you're dealing with expenditures in speech. And the court has said that it's relatively minimal scrutiny that applies because the speech is simply symbolic. And one can contribute a total of $48,600 to individual candidates. One could give, quite a large amount to many, many candidates. It may not be the full $2,600, but you could give $1,000. You could even give $500 to a heck of a lot of candidates in a way in which you say, I'm making my symbolic effort of demonstrating that I support you. And then the only question becomes to the candidates in a position in which they can't raise enough money in order to run effective campaigns. And we're living in a day and age in which the candidates and political parties in the last election cycle spent over $5 billion. So that's not a concern.
I'd just make a couple of points. The $194,000 figure, which assumes that a contributor would give the maximum amount of $32,400 to each of the national political committees each of the 2 years in the cycle, times three national political, times three, it does come up to that number, and I think that's a good number. And let me tell you why. Under the current aggregate limit, the like-minded political parties aren't cooperating with each other to elect candidates on their slate. They're competing against each other for dollars. And all of them will tell you that. They're competing, the national committees are competing against the state committees, and the three national committees are competing against each other, because you cannot give the maximum contribution to all three of the national committees. And if you max out at the national level, that leaves you nothing for the state parties. Now, that is not a good thing. And it is not a good thing because we're in an era in which the political parties in this country are being marginalized by the independent groups that are raising and spending billions of dollars to promote, frankly, more extreme agendas. Some of you have probably been involved with political parties, and I certainly have. I've represented them as a lawyer. I've worked with political parties. I've worked in a presidential campaign. I am firmly of the view that one of the great things about this country that has allowed this country to survive as a democracy for as long as it has been a strong two-party system. The two-party system, they don't agree. They're not supposed to agree. But within each of the parties, they do have a moderating effect on their more extreme members. And so when the Republicans all get together and come up with a unified view of what the Republicans are going to do, and the Democrats come up with a unified view of what the Democrats want to do, it's a lot easier to sit down at a negotiating table with two parties in the room than it is with what we see now, which is, you know, extreme people on the left and extreme people on the right who are moving the agendas. That situation is even worse with the redistricting that we've seen in this country, where most of the congressional districts in this country are safe districts. There are only a handful, probably several dozen, where the elections are considered to be contestable elections between Democrats and Republicans. For the safe districts, I can tell you this for a fact, the principal concern of the people sitting up on Capitol Hill right now is not their general elections, it's being primary. On the Democrat side from the left, on the Republican side from the right. Now, what is that doing to the culture in this country, and what is this doing in Washington? I don't have any empirical basis to support this, but I think you'll see what I'm saying. What you're seeing is the Republicans are being pulled further to the right, and the Democrats are being pulled further to the left. They're being pulled away from the center, and that has caused a lot of the gridlock in Washington, because by neutering the parties, as I think the McCain-Feingold bill did, and by releasing these independent groups to spend at will, you are neutering the parties and eliminating their moderating influence on the political system, and that is a bad thing. So yes, I think allowing someone to give $195,000 over a 2-year period to the three national political committees, and to give $10,000 to their home state party and $5,000 to their local party. I think all of that would be a great thing, because it would help put the political parties back in the game and make them factors again.
Yeah, and I certainly agree with Bobby with respect to the problem that exists in politics today, and certainly very much share his desire to have a world in which our elected officials are able to come together better and sort of find solutions, and where there's less divisiveness. I disagree, though, about the cause. At least I haven't given enough thought to all of Bobby's list of causes in redistricting, and there may be something there. I'd like to think about that. But the one that I do disagree with was the fact that it's the McCain-Feingold bill or aggregate contribution limits that caused this. And just sort of two thoughts on that. One is that, as I mentioned earlier, in 2012, the federal candidates in their parties spent $5.2 billion on the election. That sort of just by itself is a heck of a lot of money, and it doesn't sound to me sort of like the political parties are struggling in a world in which they themselves, there's just the two major political parties themselves spent $2 billion in 2012. It sounds as though they've got money to do what they need to do in that regard, whereas the outside groups, at least to the extent it was reported, spent only $1 billion in that same election cycle. But the other point I wanted to make is that addressing a somewhat different point, Justice Kagan, towards the end of the argument, sort of posed the question of whether the real problem here, and this will bring us full circle for purposes of our discussion, whether the real problem here and the problem that some of the justices were raising was a result of the aggregate limits, or whether the real problem was the result of the Citizens United decision. And it is the Citizens United decision which has fed precisely what Bobby is talking about, which is sort of the empowerment of these outside groups which are funded by the corporate treasury funds in a way that perhaps is tilting things away from sort of the political parties and away from where it has been in the past. But that's not a result of the aggregate contribution limits, it's a result of the Citizens United decision.
I disagree. I think the numbers of the amount of outside spending is higher than your estimate, but be that as it may, I think a lot of the outside spending is not corporate outside spending, it is individual outside spending. So Citizens United didn't really have much of an effect on that. There are what are known as super PACs, which can take large individual donations. They report to the FEC. Obama had one supporting him, Romney had one. They collectively spent over $100 million in the presidential campaign supporting the respective candidates independently. And Gingrich had one, and Rick Santorum had one. So there was a lot of money that was going in that way, individual money, not corporate money. So I think it is. I think the attributing all of that to Citizens United is probably not accurate, but more fundamentally, the question remains: is it appropriate in this country with our tradition of free speech for everyone? As Justice Brennan put it in the New York Times versus Sullivan case, the unfettered, robust exchange of ideas, is it consistent to muzzle corporations in that regard? And I continue to think that's a very slippery slope to go down.
Yeah, and I'm glad you raised that point, Bob, because I do think that sort of in the nature of the debate, one comes in here and one takes a position and forcefully advocates for the position you're taking in the debate. I do think that First Amendment values in this area are incredibly important, and I do think that we need to be sensitive, very sensitive, and guarded about the First Amendment in this area, and making sure. And I am glad to have Bobby and anyone else out there as the champions of the First Amendment, because I think it's essential that we be doing that. I do think, though, that one is Justice Breyer is fond of saying, is there are First Amendment values on both sides of the issue here, and the rights of the public to participate in meaningful ways in the democratic process is at stake as well. And whether one treats that as a traditional First Amendment value or just as a core constitutional principle that has equal stature, to the extent democracy is at stake, that is also something we have to be very guarded about. And that's why this is all so incredibly important. And it's important that the courts get it right, and that we all get it right, and that we debate this and think hard about it, and we ought to continue every day thinking hard about this, because there's nothing in this country ultimately that's more important than balancing those types of concerns of the First Amendment and core democracy, and figuring out as a country how to balance it in a way that is protective of what's important to us. And both of those values are deeply important.
Let me ask one more question, then we'll turn to the audience for any questions. So sort of a wrap-up, but you can take it where you will. One question I did want to ask you, are these issues, I guess two different things. One I know came up in the argument today. Are these issues an incumbent versus challenger, in that the incumbents set the rules, so they're trying to sort of make safe their situation in Congress, and so we should be wary for that reason? But also, is it a partisan issue? Is there a Democrat and a Republican view all of these things, or is it really more complicated than that?
To take your second question first, I know Republicans. We have a mutual friend who's a Republican who is one of the most ardent advocates of campaign finance regulation. I don't think it's necessarily a partisan issue. I also have good friends, and Randy would know some of the ones I'm thinking of who are also ardent First Amendment anti-campaign finance regulation advocates. So I don't think it's necessarily a partisan thing. It does tend to be identified closely with the Republicans as being against campaign finance regulation, but not necessarily so. In the Buckley case, and again in McConnell, the ACLU was in very much on the side of the challengers, and they're not typically known as a Republican group. So I don't think that. And your other question?
Sort of the incumbents. Is there any reason to be mistrustful of campaign finance because of who's setting the rules?
I know a lot of the incumbents on Capitol Hill. I represent some of them. I represented one of them today. I'm generally very skeptical of incumbents. I think they're somewhat skeptical of themselves. But I do think that that if you look at the campaign finance regulations and some of the provisions in particular, you would have a hard time coming away not seeing some incumbent protection aspects of it. One provision in the McCain-Feingold bill was what was known as the Millionaires Amendment. The Millionaires Amendment basically said that if a candidate was running for election and decides to self-fund his or her own campaign with his own money, that the law would then raise the contribution limit for the challenger. So just to put this in context, the Supreme Court has held that a Ross Perot spending his own money can't corrupt himself, so he can spend as much of his own money as he wants. And Ross Perot, as you all know, did that. He spent close to $100 million on his campaigns in '92 and '96. Well, what the Millionaires Amendment tried to do was it tried essentially to punish a self-funding candidate for putting his own money in by raising the contribution limits in tiers for a Senate challenger or for a House challenger, so that the $2,600 limit would go up to, say, $5,200, and then it would go up to $7,800, and then it would finally go over $10,000, the contribution limit, for the opposing candidate, whereas the one self-funding would keep his limit at the same level. There are also significant reporting and disclosure requirements on self-funding candidates. The Supreme Court struck that down as essentially an incumbent protection measure and as an effort to impose a burden on self-funding candidates for exercising their free speech right of spending their own money. So I do see some aspects of that in here.
Yeah, and what I would say about the fact, whether this is a bipartisan issue or not, is in the McConnell litigation, I represented John McCain and Senator Feingold. I represented Chris Shays and Marty Meehan in that litigation. And I was just taking a look on the internet sort of an hour or two before we started here, and found that the very last legislative act that Senator Dole did before leaving the Senate was to introduce a campaign finance bill. He was sort of frustrated by the inability of Congress to do anything, that he had proposed creating a commission and that would make recommendations for campaign finance reform, and that Congress would sort of agree to a fast-track approach in which they would have an up or down vote on whatever this commission recommended. So I don't think it's a partisan issue in that respect. And with respect to incumbency protection, I do think that it's something that, you're dealing with First Amendment issues, you're dealing with protecting democracy, and you need to ask that question when you look at particular campaign finance measures. Justice Scalia today sort of posed a question and said, when I look at this law, I say to myself, what's in it for Congress? Why do they pass it? And he had some explanation of sort of why the aggregate limits were actually in the incumbent's interest. I didn't get it. It may have been self-evident to Justice Scalia. It didn't occur to me, and I'm not quite sure how I see this how this law is one where there's any obvious bias towards incumbency. And the final thing I would say about incumbency protection on this is that, one of the reasons that it is so important to uphold these laws where they're constitutional and can be upheld, and not simply say, let's just send this thing back to Congress, let them tinker with it a little bit, see if they can tailor it a little more. It is hard to actually get this stuff through Congress. Congress, if this was simply about Congress sort of protecting its own interests, you might think, oh, they'll just pass a bill. The prospect of getting Congress to pass legislation in this area is very, very hard. I mean, the Bipartisan Campaign Reform Act is the only major legislation that has been passed in this area since the 1970s.
It is interesting. I'll say this quickly, and that is each of the modern era campaign finance reform, major campaign finance reform legislation bills was signed by a Republican president. 71, 74 by Nixon, 76 by Ford, and 2002 the Bipartisan Campaign Reform Act became final, signed by President Bush. So I don't think this is necessarily a Republican versus Democrat issue.
All right. Do we have our mics ready? Questions from anyone in the audience? There.
My question is that, given my understanding of the Citizens United holding, core political speech encompasses all forms of political spending. So my question is, when did that become the case? When did all forms of political spending, regardless of the source, become core political speech?
Do you want to start with that?
The court in Buckley, there has been at least one Supreme Court justice, Justice John Paul Stevens, who Randy clerked for, right?
Yes.
Who took the position that money is not speech, it is property, and he essentially disagreed that there was really any substantial First Amendment right, First Amendment protection in the campaign finance area. But the consensus of the other justices who have served over the last 40 years has been that money is essential to political speech. Saying you can speak up to a limit is like saying you can drive your car as far as you want, but we're only going to give you one tank of gasoline. So every form of communication, perhaps the internet is a little bit different in this era, but essentially every form of communication, from renting a megaphone to a TV or radio ad to a newspaper advertisement, it requires money. And if that money is used to buy political speech, as campaign money does, then you can't separate the two. So campaign finance became core political speech because that's what campaign finance does. It finances speech. It enables political speech.
It was in Buckley versus Vallejo where the court held that expenditures by individuals was core political speech. It was not until the Citizens United decision itself that the court held that the same held true for corporations.
I was glad to see that you both recognize that so-called reform is partly an incumbent protection device, but I don't think you go far enough. You both used the term outsiders, and I think part of campaign finance is to reduce the power of outsiders to challenge incumbents. And the overall laws make it harder for challengers to raise money. And are you familiar with the literature on this that says basically this is what's going on here, a incumbent protection racket?
I actually am familiar with literature in this area, probably not all of it, but I am familiar with some of it. And I think you're right. And one of the points I made this morning when Justice Scalia said that he thought the aggregate limit was an incumbent protection matter, I responded by saying that Congress has constructed a separate aggregate limit for for candidates and then another aggregate limit for political committees, and that insulates primarily the incumbents from having to compete with the political parties for campaign money. It's two different checkbooks. So I take that point, and that's something that I do think that the courts need to watch carefully. I know Justice Scalia watches it very carefully. He feels very strongly that a lot of these laws are incumbent protection laws, and he's very concerned about that. Now, not all of them are incumbent protection laws. I think some of them can be applied fairly. I think the limit, the contribution limit in concept can be applied in an even-handed way so as not to favor incumbents as much. But incumbents are always going to have a huge advantage. I mean, the state senator can always get on TV anytime he wants to. Your local congressman can hold town hall meetings. Those are huge advantages. Incumbents always have an uphill fight until you start talking about the incumbent's record, which they really don't like very much.
Yeah, and the big advantage that incumbents have is that it's actually easier for them to raise money, and it's easier for them to raise money, particularly in a system without caps, because people feel as though they need to contribute to the incumbent because they may need something from the incumbent. I know there's been a great deal of sort of attention and focus on sort of what one does to empower challengers. One thing that one could do to empower challengers that we've never really taken on in this country, it would be public financing of campaigns that would put challengers in a position in which they really could raise money in a way to get their message out and to be heard in competition with the incumbents.
That issue, and this is a proposal that many very thoughtful people make, and there are many advocates of public financing of campaigns. But let me give you one statistic on this. I'm not a fan of public financing because I think citizen participation in the process is important, and I think public financing always comes with strings attached to it, as any kind of government funding does. And the string that's attached to public financing is you have to take our money and take our limit on how much you can spend. That's the way it was in the federal public financing system. If you took the federal money, you were limited in the amount of money you could spend, and now that system is completely dead. It's been I doubt any major party candidate will ever accept public financing again under the system. But let me give you one set of data, and I've got the precise data back in my notebook, but I'll give you a few pieces of data. Every year when you file your income tax return, there's a little box on there that says, would you like $3 of your tax money to go to the public financing fund for presidential campaigns and conventions? And if you check that box, it doesn't cost you anything. It just means that $3 that you would already pay will go into the public financing fund. So it's an absolute cost-free way to vote for or against public financing. When that checkoff was first established in 1976, following the 1974 reforms, close to 30% of the American public checked off that box. By 1990, it was down to 20%. By 2000, it was down to about 15%. What do you think it was in 2012? Anyone want to venture a guess? 5.1%. There is your public vote on the popularity of taxpayer-funded elections. I don't think it's ever going to happen, and I frankly don't think it would be a good thing.
Hello. During the 2012 election, I kept hearing the issue raised that campaigns or candidates didn't have to disclose where their money was coming from large contributors. My question is that issue tied to Citizens United? And if the issue at stake is corporations having free speech to give money, should the public be able to know who's contributing and who's backing different candidates with all the money they're giving?
I'll go first. There are respectable academicians out there who say, I'll make 3 points. First point is there are respectable academicians out there who say blind contributions are better, because if you don't know where your money's coming from, you won't know who to repay the favors to. Now, I don't necessarily support that view, but that's a thought-provoking position. The second thing I'll say about disclosure is disclosure. I am an advocate of disclosure of contributions directly to candidates and to party political committees. I think once you get beyond that, it begins to create some issues. And let me tell you, and this is the third point, let me tell you what those issues are. It is that the disclosure is often being used not to inform the public of who is donating and financing the speech, but to suppress the speech. When Senator Schumer and Congressman Van Hollen proposed their so-called Disclose Act, which would impose substantial new disclosure requirements on corporations that make expenditures through various types of committees, they touted the bill. Senator Schumer specifically said, if we pass this bill, the money behind this speech will dry up. So I'm very skeptical that the reason for these disclosures is to inform the public as opposed to deter the speech. And that's a concern for me, because I think the speech, more speech is good speech. As for the anonymity of the speech, and we talked about this in our dinner, the Federalist Papers, we now know who wrote the Federalist Papers. When they were initially published, they were published by Publius. And we also know that when newspaper reporters do some of their best reporting, particularly in Washington, the sources are often anonymous. And there's a First Amendment right for them to protect their anonymous sources. And why is that? Because people speak more freely. They say things anonymously that they might not say if they had to attach their name to it. Some things might not even be said if they had to be identified. So I think that the primary value here is unfettered free debate. The primary value is not disclosing, because disclosure can sometimes operate at odds with unfettered debate. So we've got to be careful about disclosure.
Yeah, although when I would say this, first of all, with respect to your question, if you're talking about contributions that were actually made to candidates or to political parties, that actually, the law does require disclosure there. And in fact, you can go online and find out who has contributed how much to political candidates. There are sites, and the FEC, I think, even posts that information. So you can go and just check that. I think where the issue is with some of these super PACs and unaffiliated groups that are engaged in political speech, and at times they are not required to disclose who their contributors are. I have to say, through the McConnell litigation and a lot of the litigation in this area, those who have been opposed to limits on contributions and other campaign regulation say transparency is the answer. And if someone is getting large contributions, if somebody as I was saying earlier, if someone is making a couple $100,000 contribution to the political parties, don't worry about that. The political process can respond to that. Just have disclosure, have transparency, and if people don't want to support a political party because they feel that that political party may be in the pocket of some interest, they can vote based on that information. So I think that disclosure is an issue that one needs to be careful about and make sure that one is not using disclosure for improper purposes or requiring disclosure of members of groups that may be subject to persecution, which is the way the Supreme Court has drawn the line in the past. But there is value in an informed public, and part of an informed public is knowing where their political candidates are indebted in the process. And if we're not going to have a system that sharply limits the ability of candidates, even indirectly, to receive massive benefits from benefactors, I think that there, at least in many cases, is a very strong public right to know who their candidates and elected officials are indebted to. And if the candidate or the elected official knows that somebody has spent millions and millions of dollars to help get that person elected, I think it's fair that the public know as well that someone spent millions and millions of dollars to get that person elected, and that when that candidate or then official goes to the floor of the Congress and votes a particular way, the public can say to themselves, I wonder whether the person voted that way because someone spent millions and millions of dollars getting them elected, or because they think it's the right thing.
This will be the last question, please.
I can vote for as many candidates as I want as long as no two are running for the same office. Can I propose
Excuse me, is that mic on, please, because we're recording this? Okay.
Can I propose that I can give money to as many candidates as I want as long as no two are running for the same office? And my idea is that if I'm allowed to give to both a Democrat and a Republican, I will feel like I have to give to both in order to not expose myself to some retaliation regardless of who wins. And if I can only give to one of them, then they have to compete for my money, and competition is always good. Otherwise, I'll just keep it in my pocket rather than expose myself to retaliation.
So your question is, please just give me the question.
Yeah. So can I propose the idea that campaign finance law is done a little bit more creatively? So you can only give to one candidate instead of one candidate running for a given office instead of every candidate who's running for the same office?
Well, this gives me the opportunity to say that, the First Amendment, I think as a matter of First Amendment, you couldn't do that. Because I do think that what the court has said, and correctly so, has said that there is symbolic value in making a political contribution, and there could well be a circumstance, and I think the government shouldn't put itself in the position of saying that you should be barred from saying, you know what, I like both the Republican and the Democratic candidate, and I want to symbolically show my support for both. So I haven't thought deeply about this, but just based on hearing it, my initial reaction is I think that would be unconstitutional, even though I sort of appreciate what you're trying to get at.
I agree with that. The one other point I'd make, and I think it's a thoughtful question. The one other point I would make is it's always been my view, and I think for the vast majority of political contributors, this is the case, that the money follows the positions. The positions do not follow the money. In other words, when I make a political contribution to a candidate, I make a political contribution to that candidate because I support his positions, not because I want to alter his positions in any way. And I said before, with the current federal limits, if you're able to get a candidate to change his position for $2,600, you're betting on the wrong horse, because a good candidate will not, that's far too low to get someone to change a position. I do believe that money follows positions rather than positions following the money.
Yeah, although, just sort of picking up on your comment, the one thing I would say about it is, although I think sort of designing a system that way would probably be unconstitutional, you do get it, you're sort of raising an interesting point, because in the record in the McConnell case, there was evidence that large corporations were giving hundreds and hundreds of thousands of dollars of political contributions in roughly equal amounts to the Democratic National Committee and to the Republican National Committee. And that does make one look at it with some suspicion and say, it sure looks like they're doing this because they feel they have to in order to engage in whatever lobbying efforts they want to engage into, and make sure that they're not alienating their members or members that they may need to go to request something. So I think it does, when you see that, and historically we've seen that behavior, it does, I think, raise a red flag as to why people are giving, large amounts of money in roughly equal amounts to both political parties.
With that, I would say We have heard an outstanding program, and I think you will leave here better informed about campaign finance than when you came here, and they were outstanding. I do want to thank the School of Law for co-sponsoring this program with us, certainly Bobby Burchfield, Randy Moss, and Steve McAllister. You can also leave here saying you saw it first. Bobby was before the Supreme Court this morning arguing this case. So I would say to you, please continue to come to our programs. We enjoyed presenting this in honor of Constitution Day, but most of all, I do want to thank our guests this evening, in which you helped me do that as well. And for all the bell ringers out there, you have one last duty. May I hear your bells, please? Thank you so very much. Safe travels. Bye-bye.